This screencast video lecture introduces the concept of objective intent to contract. You've read the principal cases, Bailey v. West and Lucy v. Zemmer, and a brief excerpt from Leonard v. PepsiCo. These cases all have something in common. Each court is trying to decide whether the parties intended to make a legally enforceable promise. We can locate that broad issue on our graphical map of the course. But we also need to know what sort of intent is required. The answer, as we'll see, is objective intent. Let's first consider what the Restatement of Contracts has to say about intent. Notice that Section 1 of the Restatement defines contract in terms of a promise or a set of promises. And Section 2 tells us the legal definition of a promise. Here's where we get some guidance about what kind of intent a court will require. To be a promise, the manifestation of intention to act must be made in a way that justifies a promisee in understanding that the promisor is making a commitment. Both the Bailey and the Lucy decisions are consistent with this principle. In Bailey, the Rhode Island Supreme Court concludes that Bailey was not justified in thinking that West had made a commitment to pay for boarding services. In Lucy, the Virginia Supreme Court concludes that Lucy was justified in understanding the Zemmers to have made a commitment to sell the farm. One key to understanding these decisions is to recognize that the promisee and the promisor are both being held to a standard of reasonableness. You will often hear courts talk about an objectively reasonable person. For now, we can use the terms objective and reasonable interchangeably. A standard of objective intent to contract requires that one party interpret the other party's conduct reasonably. So what would be unreasonable? I can give you some extreme examples. Imagine someone who thinks that you only have a contract if you pinky swear, or that a blink means, yes, I agree, or that you can only make a binding contract on Tuesdays. It's also worth considering how a court will determine whether a party's understanding is reasonable. Do they commission a Gallup poll, hold a referendum? Not likely. A hint to the possibilities is to think about who is in a courtroom. We have witnesses, and so the court might hear expert testimony. That turns out to be the unusual case. The parties are more likely to testify themselves and to offer documentary evidence. And if it is a jury trial, we may leave it to the jury to decide what is reasonable. In that case, the court treats reasonableness as an issue of fact and lets the jury, as fact finder, make a decision. In a bench trial, like Bailey, the judge is the fact finder. She will presumably rely on judicial introspection and evaluate the testimony and other evidence. Even when the parties have elected a jury trial, the judge may still issue summary judgment. In that case, the court resolves the question as a matter of law and thus takes it away from the jury. Notice also that the legal rule of reasonableness penalizes people who, like Bailey, have idiosyncratic or unreasonable expectations. What will be the prospective effect of that rule? How do the Baileys of the world have to respond? Imagine that you were a Bailey. What do you have to do? Please pause the video here to think about this question and then jot down your answer. Did you come up with a good answer? What does a Bailey have to do under this rule of reasonableness? The Baileys of the world will have to learn that their expectations are abnormal, and then they must adjust their reliance on promises accordingly. But why should the idiosyncratic Baileys have to change rather than the reasonable non-Baileys? One way to think about this problem is to ask who can most cheaply avoid the misunderstanding. In tort law, for example, you'll often hear references to the cheapest cost avoider. Guido Calabresi is most famously associated with this idea in his book, The Cost of Accidents. The argument that follows says that we should impose liability on the cheapest cost avoider because that will encourage him or her to take precautions and prevent the harm. It is more common in contract theory to refer to the principle of comparative advantage in taking precautions. we impose legal duties on the party who can most easily avoid the loss. In this case, the argument would be that Bailey had a comparative advantage over West in preventing the misunderstanding about who would pay for boarding Bascom's Folly. Note that if you've studied international trade theory, you'll recognize this situation as one of absolute advantage rather than comparative advantage. But as you can see, contract theorists use the term comparative advantage differently. Now let's see how this same reasoning applies to Lucy against Zemmer. Zemmer contends that the contract to sell the farm, pictured here, was all bluffing, a big joke. Well, with inflation, it was a $350,000 joke. So what exactly did the Virginia Supreme Court decide about that fateful night in the Old Virginia restaurant? That Lucy was justified in interpreting Zemmer's words and actions as assent to the contract of sale. That is, as a commitment to sell the farm. Ask yourself if it would be enough to find merely that Zemmer did not intend to sell the farm. And why or why not? Please pause the video to think about this question and then jot down your answer. Did you come up with a good answer? Well, would it be enough? No. The trial court would have to find that Lucy had reason to know that Zemmer's execution of the written contract was not in earnest. The Virginia Supreme Court's decision here rests on the finding that Lucy reasonably interpreted Zemmer's words and actions to express a commitment to sell the farm. And that's what we mean when we say that he had an objective intent to promise. So that's definitely the law, don't ever forget it. Look very carefully at the Lucy decision. See if you can find any evidence in the opinion that the court also considered evidence of Zemmer's subjective intent to contract. By subjective intent, we mean what Zemmer thought he was doing, not what Lucy was justified in thinking Zemmer was doing. Finally, we can briefly compare Leonard v. PepsiCo. Recall that in Lucy, the court's analysis focused on how a reasonable person would interpret Zemmer's words and actions. Let's apply the same principle to Leonard. What's the analysis? Well, the ad is obviously humorous, and no reasonable person would think that Pepsi was offering the Harrier jet for 7 million Pepsi points. After all, it involves a comic plot that presents really an adolescent fantasy. The Harrier jet is a military aircraft, and there's a huge disparity in value between the points, $700,000, and the jet, about $23 million. An equally telling problem for Leonard is this. The ad begins with the phrase introducing the new Pepsi Stuff catalog, but the jet is not in the catalog, or on the order form. Even Leonard looked first in the catalog and sent in the order form modified to add the jet, with $10 for shipping. This is an easy case. You can read more about it online. Leonard was a 21-year-old business student from Shoreline Community College who sued in Dade County, Florida. He said he would use the jet as a thrill ride. Pepsi had already filed preemptive suit in federal court in New York, and that's the decision quoted in our textbook. Do an exercise that puts you in the role of an attorney for PepsiCo who is asked to review the ad before it airs. Also consider whether it might be better to make advertisers responsible for even Leonard's unreasonable misunderstanding. Thanks for listening.